Ксения Андреева и Pulina Whitaker. Значит, Ксения, подскажите, пожалуйста, вы будете доклад вести на английском целиком, либо на английском и русском?
Да, здравствуйте. Мы будем вести доклад на английском, но будем готовы, если что, отвечать на вопросы на русском. И попробуем, если будет коллегам интересно, изложить тоже нашу... Сама презентация сейчас на английском, но мы готовы будем ее повторить для коллег и на русском тоже, и как дополнительные материалы оставить.
Великолепно. И давайте тогда я представлю, во-первых, начну с модератора, и тогда вас представлю, Кристина и Паулина. Модератором дискуссии выступит Кристина Боровикова, с которой вы уже хорошо знакомы по ее модерированию многих докладов и ведению панельной дискуссии сегодня. И с нами сегодня Ксения Андреева, партнер практики телеком, медиа, технологий Morgan Lewis, рекомендованный ведущими международными рейтингами Legal 500 и The Best Lawyers, и Pulina Whitaker, co-founder of Morgan Lewis Global Privacy and Cybersecurity Practice. She assists international clients to manage compliance requirements and data breaches across the globe and provides practical, pragmatic, strategic advice on those complex issues. So I'm turning the floor to Ksenia and Pulina and hope for... just let now you can say hello to our audience, but it will take a couple of seconds for me to switch into your slides and provide you with the presenter rights.
Сергей, я бы еще хотела добавить небольшое вступление. Очень рада видеть сегодня здесь Ксению и Паулину, потому что мы косвенно были знакомы. Paulina, greetings. Thank you for your participation in this event. So, and the topic will be legitimate interest concept and legitimate interest assessment. As for me, it is really a very interesting presentation because its a legal basis is not so easy to implement, to be honest. So I share my words with Ksenia and Paulina, and good luck.
Thank you.
Thank you. So perhaps if I start, thank you very much everyone for joining us today for our session on legitimate interest processing. As introduced, I'm Pulina Whitaker, a partner in our Morgan Lewis office in London and one of the co-leaders of our global privacy and cybersecurity practice. And I'm delighted to be joined today by my good colleague, Ksenija Andreeva, in our Moscow office, with whom I have a great pleasure of collaborating very often. So we're going to be discussing legitimate interest. I will be covering the European aspects, the concept that is very much entrenched in European privacy laws. I know that's not the same around the world. And of course, Ksenija will be talking about how this concept is used in the Russia privacy requirements and regulations. So turning to the GDPR, which is obviously now our primary piece of law, it is always important to remember that we don't just have the GDPR in Europe, we have 28 other laws that give effect to the GDPR. And lawful processing of personal data exemptions are, very much a domestic interpretation. So the UK law, the Data Protection Act, has examples of legitimate interest processing that are very specific to UK controllers and UK processors. And that is the same across all of Europe. Every country now has its own supplemental data privacy laws that are very jurisdiction specific, where that is permitted under the GDPR. And legitimate interest is one of those examples. So just in terms of the GDPR framework, we first come across legitimate interest as a concept under Article 6, which is the main processing ground for kind of ordinary personal data, i.e. personal data that is not falling within this special category of personal data, which is Article 9 of the GDPR. And that kind of data is really very highly sensitive. It is trade union data, biometric data, that sort of data. So just for ordinary, as it were, personal data, legitimate interest can be a ground for processing personal data. It is also, further into the GDPR, it's also used in the concept of making very limited, non-repetitive, one-off transfers of data from Europe or the UK to an organisation outside of Europe and the UK. So if legitimate interest is used as the one-off ground for making a data export, there has to be a dialogue with the supervisory authority in that country, and that gives the supervisory authority the ability to object to that processing notice if it feels that there's a risk to the interests of those individuals. We see it practically and sort of often, in a commercial context, used as a sort of sweep all or catch all ground. It's certainly not supposed to be a sort of default ground, but it's often used instead of either consent or contractual or legal grounds for processing. So frankly, it's a really useful ground to be relying on, within the European context. I'm going to come on a bit later in our session with some examples that are given in the GDPR and some examples that we see often in practice when we look at legitimate interest as legalizing that data processing activity. One of the really good things about the GDPR compared to the old regime, I don't often say that, but one of the good things, flexible things, is that legitimate interest doesn't have to be just in the parties' legitimate interest. It can actually be in the legitimate interest of a third party, so a party that is not related to the processing activity, but that ultimately has an interest in that processing activity taking place. And certainly the guidance that we've seen coming out of Europe also emphasises that legitimate interest processing can be relied on where the processing is in the greater good, the public good, or the social good, that sort of context. So we have come across that, for example, very practically when advising a technology company in putting together a database where information had been scraped from the dark web, and we were really sort of unsure whose legitimate interest we were relying on in that case. We had a dialogue with the UK supervisory authority, and they confirmed we could rely on legitimate interest as well as a few other grounds, but the legitimate interest was actually just the public good, because it was for law enforcement purposes. So when we talk about legitimate interest processing, the UK authority has very useful guidance. I'm very willing and able to direct anyone who sends me an email to the website, which has the link, but it's on the ICO website. And it talks about a three-part test that should really be contemplated when looking at legitimate interest processing. The first part is the purpose test. Is there a legitimate interest behind the processing? Secondly, necessity. Is the processing necessary for that purpose? And that's a very restrictive term. The concept comes up time and again in European data protection law. You can't just use it just in case it's relevant. It has to be actually necessary for that purpose. And then finally, the balancing test. Is the legitimate interest overridden by the individual's interests or rights or freedoms? And from a European perspective, it is very important to bear in mind that the concept of privacy in a European context is very much a fundamental human right. It's very different in other cultures and in other countries, but from a European perspective, it is deemed to be a fundamental human right. It is within our human rights laws in Europe that have been enforced for a long time. So practically, being very sort of pragmatic here, the controller needs to have actually thought about it. They've got to have decided what is their interest or benefit or outcome. And then if it's sort of relevant, then and they rely on legitimate interest, that has to be for that particular decided benefit or outcome. Because it's legitimate interest processing, it has to be both ethical and lawful. There has to be literally a legitimate interest. So just going through, essentially a sort of practical checklist for whether legitimate interest can be used in a particular context. An organisation needs to have thought about the following things. They've got to have decided and checked that legitimate interest is in fact the most appropriate basis for using the data. They've got to understand and confirm that it is the organisation's responsibility to protect the individual data subjects' privacy interests. They've got to have conducted a legitimate interest assessment. I'm going to come on to what that means in practice, and kept a record of it to ensure that the company can justify its decision to use legitimate interest processing as the lawful basis. They've got to have checked that the processing is necessary and there isn't another alternative, less intrusive way to achieve the same result. And then they've done the balancing test. They're confident that the individual's interests don't override that legitimate interest. They've then also got to be sure that they use the individual's data in a way that they'd reasonably expect, unless there's a really, really good reason, a lawful reason, as to why they can use the data without that being within the reasonable expectations of the individual. And they're not using the data in a way that would be intrusive or would cause them harm, again, unless there's a very good and lawful reason for that. And if children's data is being used, certainly the organisation has considered all the obligations and the extra care that's needed to make sure that those children's interests are protected, to a much higher standard. So again, it's a jurisdiction-specific concept. Each country will have their own regulations and guidance around children's privacy. We have a code of conduct in the UK, for example, for retailers and other online e-commerce sites that have to that will market and take data of children through purchases and subscriptions and offers and that sort of thing. And then the organisation has to have considered the safeguards in place to reduce the impact of processing, if that's at all possible. They should consider whether they can offer an opt-out from the legitimate interest processing. And if there's a significant privacy impact identified in that legitimate interest assessment, they have to consider whether they would also need to conduct a data privacy impact assessment. And that is required where there's some sort of technological process that is likely to create a risk to the rights and freedoms of the individual. If that DPIA concludes that there's likely to be a high risk to individuals, then there's a requirement to consult with the supervisory authority in that country, and no processing can take place until that consultation process has completed and the supervisory authority agrees that it is, it can continue. And then finally, in terms of the checklist, the organisation has to keep the legitimate interest assessment under review and redo it if circumstances change. And then they've got to finally include information about legitimate interest processing in the privacy notice or the privacy policy that goes hand in hand with obligations to have a lawful process, a lawful basis for processing. I'm just going to turn to the next slide here, which is about, really sort of practically, how can it be used in practice? As I've mentioned, it can't be a default ground, but is often practically, a catch-all. So organisations will often identify what is within the contract, what is within legal obligations, and all the other lawful processing provisions, including consent, if consent's applicable. And then for legitimate interest assessment, that's often used in tandem with, for example, contract or in tandem with consent. It's often it's not a ground relied on its own. And where it is relied on its own, it's often very difficult at the beginning or at the outset to predict every single ground of legitimate interest. So kind of categories of legitimate interest processing is often described in a privacy notice, for example, marketing or investigations or administration of justice or something like that, that wouldn't necessarily squarely fall in another category or where there's an overlap, as I mentioned. So it's certainly important from a documentary perspective to conduct and retain a record of the legitimate interest assessment. And what that really means is, you need to have a record of it in case it's required. There's certainly a general requirement, not a statutory requirement, to conduct one. So it's for good record keeping purposes. In case a complaint is made, you have it to hand to produce to the supervisory authority that shows it, even if you're ultimately wrong to conclude you had a lawful or legitimate interest ground, at least you've gone through that process of considering, and so that should hopefully reduce any risk of getting a serious sanction. It might well be that you just get some guidance and advice from the supervisory authority if it concludes you were wrong to use legitimate interest processing for the particular ground. So in terms of what should go in it, it should really follow that three-part test that I mentioned and is set out on the previous slide. What's really important is whether the individual would expect the data to be used in this way. So it really has to not be a surprise, ideally described, even if broadly, in the privacy notice or the privacy policy. And then, what's really important is that if the data that is initially processed on legitimate interest basis is then used for a different purpose, it's really important to check again and make sure you have a lawful processing ground that applies. And if there isn't any other processing ground and you still need to rely on legitimate interest processing, then it's important to either update the privacy notice or just otherwise send a notice to the data subject that this isn't the basis in which the data is now being used for these secondary purposes. In terms of how it can be used in practice, the GDPR does give some examples in the recitals, and there's some other examples that are sort of published in supervisory authority guidance notes. So fraud prevention is a really good one. That's really one of the grounds that we used in the dark web scraping database that one of my clients had put together. Ensuring network and information security is another one as well. Often networks are tested, and as a part of that test, information is gathered, and that can contain personal information, but not necessarily going to be specifically included in the transparency notice, but broadly wouldn't be unexpected as far as an individual is concerned, frankly. Indicating possible criminal acts or threats to public security is also a really important ground as far as organisations that are involved in that in that sector. Often it's used in the context of processing employee or client data, and that's quite important because I think a lot of organisations think that if they haven't got consent, they can't really rely on processing personal data, and so they try and get consent as broad as possible. But frankly, consent from an employee is always going to be very difficult to rely on, because the GDPR standard is that it has to be freely given as well as fully informed, and consent from an employee in that very imbalanced employer-employee relationship is very unlikely to be freely given. And I certainly always advise my clients when looking at employee privacy notices that consent should really not be in there at all, and other than for very, very specific, unusual circumstances, but not for general processing of data for the purposes of the employment contract or providing benefits or trips or marketing activities involving the employee promoting the activities of the organisation. Direct marketing is a ground that can be used, and there's a really good section in the legitimate interest guidance note that's produced by the UK authority that specifically deals with direct marketing. It specifically deals with B2B or B2C marketing and how that can sometimes be different for legitimate interest processing. Of course, if you're processing the data of a business customer, that's less intrusive than if you're processing it of an individual consumer. And then administrative transfers within a group of companies can often will fall within legitimate interest processing. Often, there really isn't any other ground other than the fact that that is the way the data flow is constructed for a particular group, particularly an international group of companies. Certainly from our experience, investigations is really an important and very, very useful reason for being for processing data on a legitimate interest processing ground. Often that goes hand in hand with compliance obligations. If it's a compliance investigation, if it's a misconduct investigation, there may be some compliance there as well, but not necessarily. It's it sort of depends on the fact circumstances, but we see it a lot for investigations. Marketing is, as mentioned, direct marketing indirect marketing is often a good use of legitimate interest processing. So in practice, it doesn't need to be a compelling, you don't have to have the world's greatest reason for processing in legitimate interest processing, but it has to be good enough. As I say, it has to be, the actual activity has got to be necessary for that purpose. You can't just, just make it relevant or sort of linked to the activity. It has to actually be necessary. And that is, frankly, a much stricter test from a European perspective. And as mentioned before, it cannot be a surprise. The individual really has to expect reasonably that this processing activity will occur with as much information in the privacy notice being included as possible, or on a privacy policy on the website. It's also a good way of discharging the transparency obligation. So just turning to data subject rights, the GDPR has many rights, most of which are sort of well publicized in the form of data deletion and data access. Just sort of broadly in terms of the process, controllers have to respond within a month of the receipt unless they can extend it by up to a further 2 months if it's a very complex or large in terms of volume, in terms of the number of requests, then it can be extended. There's a right to refuse the request altogether if it's manifestly unfounded or excessive. So, for example, if somebody is saying that they will withdraw the request if they are paid compensation. And unlike before, the controller cannot charge a fee, again, unless there's a very limited, manifestly unfounded or excessive reason for doing so. But as I say, that's the alternative for not replying at all. You can charge a fee for reasonable copies if somebody's already received a copy of their data and then just repeats the same request or very similar request because they've mislaid the original copy, for example. Then you can charge a reasonable fee for providing that alternative copy. So in the context of legitimate interest processing, one of the sort of less publicised rights is the right to object for legitimate interest processing. So as I've mentioned, it's extremely useful. We find it such a sort of helpful ground of lawful processing, but the individual has got the right to say, I object. I object to the use of my data that's being processed on this ground. You therefore have to find another ground to continue to process my data for these purposes. And in this event, if this objection is received, you do need to have a compelling legitimate interest to continue processing. So a couple of things to consider if that happens, and certainly in my experience in 2 years of the GDPR being in force, this is not something that happens very often. We've certainly come across it in my team's practice a few times, but a few times over 2 years is really a very low proportion. As I say, most of the requests are for deletion of data or for access to that data. What the guidance says and what the supervisory authorities seem to be coordinated in saying is that the organisation just needs to have stronger justification if it's to continue processing on that ground. So a couple of things to think about. One is, what does your legitimate interest assessment say? Is your stronger justification going to be different to what's already in the assessment? If it is, then certainly I'd always advise rethinking that legitimate interest assessment and maybe redoing it with that stronger justification very clearly referenced in the assessment. It's important to think about whether there's any other ground of processing as well, particularly taking into account the objection that's raised by the individual. So as a sort of initial position, full details of the objection really should be obtained. I think it shouldn't be enough just to take it at face value. If somebody says I object, an organisation shouldn't just sort of take it and then sort of decide. You should sort of seek to explore the reasons for that objection just to really kind of get to the bottom of it. If you're relying on a stronger justification, that stronger justification should also take into account the details of the objection, as well as if the organisation thinks it should then find another ground. And as I say, often there's an overlapping ground for where legitimate interest processing is used. It's really important to be prepared, from a record-keeping perspective, to justify it both to the individual if they make a complaint, and also to the supervisory authority if they make a regulatory complaint. So whether to the court or escalating it within the company or directly to the supervisory authority. I'd certainly be really prepared from a record keeping perspective to have a few things ready to submit to the supervisory authority because they're likely to be requested. One is the legitimate interest assessment, as I say, important to make sure that that is completely comprehensive if you're relying on a stronger justification. And then secondly, all the other records that you need to have in place that go with that processing activity being lawful, like the privacy notice or the privacy policy sets out all the information that's, as to how data is being used. And also if it's a larger organisation, then the actual record, the log of processing activities, which should also include a specific reference to legitimate interest processing, where it's used in this particular context. Those are the two documents that are really likely to be requested in addition to the legitimate interest assessment. And with that, I'm going to
Dear Paulina, thank you for the explanation. I have one question which is connected with your presentation and this part. What do you think? Should the data controller share the results of legitimate interest assessment with the data subject, or it is will be enough to prepare some notice for data subject separate from the results of legitimate interest assessment? What do you think about this?
That's a really good question. I would often advise legitimate interest assessments as well as data protection impact assessments to be conducted under the cloak of privilege. And so, it's really important, unless you've got a request from a supervisory authority for a disclosure, that you retain privilege. So certainly my instinct and my sort of initial advice to an organisation in that situation would not be to disclose the actual assessment, but certainly, as you say, to extract the relevant details and put them into a separate document and be prepared to share that with the individual if you're going to continue to rely on legitimate interest as a processing ground, albeit with your stronger justification.
Okay, thank you.
Thank you. Great, and with that, I'm going to hand over to my colleague Ksenija.
Oh, sorry, I have one more question also, but because I think that you will be continue. So, Paulina, what do you think? Can we connect the DPA assessment and the legitimate interest assessment in one exercise? Because, as I noticed, there are some basic points which are linked between each other. For example, the description of data processing activities is in legitimate interest assessment and in the DPA, and some description of technical measures, security measures. So what do you think about the connection of two of this one? Thank you.
Two assessments. Yeah, again, a very good question. I haven't seen it done, I have to say. Every time I've looked at them for clients, we've always had them separate. I think if you were to try and merge it, I think probably you could do it, but I think it could be quite sort of complex, particularly because they're for two very separate purposes. Your data protection impact assessment is only if you think there's likely to be a high risk to individuals. And I think if you're looking at high risk processing, you hopefully shouldn't be looking at legitimate interest processing for the same activity, because, as I say, legitimate interest processing should really be, with all the safeguards already, in place, as well as, the sort of the lack of intrusion in terms of the nature of the activity and the fact that it shouldn't be a surprise. As I say, I've never seen it done. I think technically you could probably do it, but I would have thought it's much better and much easier in practice to have them separate, as I say, for two separate sort of processes. If, for example, though your legitimate interest assessment concludes there's likely to be a high risk, that of course triggers the requirement to do a DPIA. Yep. You could at that point, I guess, merge the sort of the consideration, so you don't have to sort of duplicate the information. But typically you'd want to keep them separate.
Okay, thank you. And what may be some maybe recommendations from supervisory authorities or working documents you can recommend us to use when do some legitimate interest assessment? For example, I know about ICO recommendations, about Working Party 29 recommendations, and CNIL. So maybe you can provide with us some another one. Thank you.
Yeah, no, absolutely. We've done we've prepared, obviously, short forms and long forms. They can be very long and they can be, you know, quite short. I would always recommend doing a short form one where you think it's likely to be, you know, a really low risk activity in terms of objections or in terms of sort of risks of, you know, of privacy intrusion for the individual. Where it's a really complex situation, or it's unusual, it's, you know, it's never been done before by the organisation, certainly the longer form one is best to complete. And the ICO has, it sounds like you've seen it, the ICO has a template at the back of its guidance note, which is really good. It's what I would call the long form one, because it does go through in detail every single thought process that the organisation should take. That is really a fantastic template. I heartily recommend it. And you know, if you've completed that template for your processing activity, I cannot see any kind of objection at all from any supervisory authority for lack of you know, going through the thought process, obviously subject to it being completed comprehensively. But as I say, that's unlikely to be the only document that you'll be asked for by a supervisory authority if there's a complaint about processing.
Okay, thank you. And also I heard that you talked about the using of legitimate interest, for example, within the international data transfers. And as I knew, according to the article about trans-border flow of personal data, you can use legitimate interest as a legal basis for the transfer to the countries outside the European Union, but with a special approval of supervisory authority, and if another legal basis for the transfer is not applicable. So do you need such legal basis for transfer in your professional career? And maybe some companies really use this, because from my perspective, our clients really are very afraid to use legal basis, legitimate interest, because they afraid to approve this one with supervisory authority. Yes. So what do you think about this? Thank you.
Yeah, really good question. So we have come across it in practice. It is it's one of the derogations from the restriction on transferring data outside of Europe and the UK. As you probably know, there are lots of good ways of doing it if you're transferring to a company or another organisation. You can have standard contractual clauses, you could have binding corporate rules, you could have the privacy shield if the recipient organisation is American and is certified under the privacy shield regime. Those are all ways of transferring data within a sort of lawful and protective framework. The derogations are applicable where you don't have that framework in place, and they set out, you know, they're obviously very, very restrictively applied, so you can transfer data again where it's necessary for any of those grounds in the derogations list. Legitimate interest isn't included in that list, but it is included at the bottom, as it were, of the list. So it's like an exceptional derogation. And we have relied on it and only because the recipient wasn't an organisation, it was an authority, it was a quasi-governmental authority is probably the best way of putting it. And the UK organisation that wanted to transfer data to it, they couldn't find any other way. There was no other derogation that applied, so they wanted to apply legitimate interest processing. It was in the context of misconduct investigation information, some of which could have included references to criminal acts, and certainly a lot of it would have been you know, very sensitive personal data. So we approached the supervisory authority for, you know, we notified them, we said that this is what we're doing. We'd had a dialogue with them anyway because we needed to do that for our DPIA, so they were already on board with it, and it was such an unusual position, sort of situation. We were very clear that it was not going to be a repetitive or a well-used route of transferring data, but it was only where the non-European authority was going to ask for specific information, having had a lot of de-identified sort of high-level information about these misconduct incidents. So yeah, definitely has been used. We've done it for an organisation, and so it's very as I say, it's a very exceptional derogation, certainly because it provides no safeguards for the individual. The authorities are very reluctant to approve them, but yeah, it certainly is there within the GDPR and has been used in practice.
Okay, thank you very much for explanation. I think it will be very useful for the speakers and listeners. So I share my word with Ksenia, and Ksenia will discuss the the implementation of this legitimate interest in the Russian Federation. So, Ksenia, if you have some time, maybe you summarize the key points of Pulina topic to share some views with the Russian speaker audience. Thank you very much. I'm muted.
Thank you, Christina. So let me probably do it this way. I will try to cover the Russian part, and then we will have it summarized if we have time at the very end of the presentation. But anyway, as we said, we will be sharing the presentation, the very same presentation in Russian as well, so that the audience who probably do not fully understand at the end of the second day of this super interesting conference, all the details of what we discussed now will be able to see the presentation in Russian, and both me and Pulina will be happy to give any additional comments and to answer any additional questions after the conference as well. So regarding the Russian privacy law and the concept of legitimate interest and lawful processing, it's really a very interesting topic for those of you who work and interact with the Russian authorities rather frequently. You might think right now what I'm going to tell you, because it's probably a non-existing concept in the Russian law. No one really wants to talk about it. The representatives of the Russian authorities sometimes just turn red and try to finish the conversation as soon as possible when you ask them questions as to whether something except for the express consent of the individual could be used to as a legal ground for data processing. But generally speaking, we are persistent, and by we I mean lawyers. So I think that we probably have even more faith in the Russian law than our Russian authorities. So we think that the application of the legitimate interest concept should be really developed under Russian law, and there are already certain provisions in the law that could be used for these purposes. And for those of you who probably do not work with the Russian law very often, just to give you a very brief background on what I mean by the existing in the Russian law provisions that could be used as the analog of those concepts that Pulina just mentioned in her presentation. So the Russian privacy law is based on the EU directive. So in many senses, it has certain close concepts to those that we heard about Pulina talking. So the GDPR concepts, for that matter, somehow already they exist in some way. Probably not always very clear and very tricky in application, but still exist in the Russian law. So one of the major differences between GDPR and the Russian privacy law is, as I said, this major assumption of the Russian authorities, and not the law, by the way, but by the authorities, that the safest legal ground for data processing is the express consent of the individual. So the general assumption is that you need to have this consent. You can process personal data if you tried your best, if you did everything you could, but you still could not have the consent. And there are certain criteria that you met in order to for you to still continue processing of personal data. So there are right now two provisions in the Russian privacy law that could be used, and they are often mixed by the authorities, and you will see it a moment later when we will be speaking about particular questions that we received from the authorities and about the examples that we know exist on the market when the Russian authorities confirmed that there is still the legitimate ground for the data operators to process data even in absence of individuals' consent. So there are these two provisions that are here on the slide. It is they are both in Article 6. They're very vaguely drafted, so there are certain interpretations that always, that you can always discuss with the authorities in case you have any requests from them, or you need to confirm to the data subject who requests information from you as to why you process his or her data. But in general, there is a possibility for you as a data operator to process data in case you do it to comply with the Russian federal laws. And I specifically stress here that the law makes emphasis on the Russian laws only. So there is this tricky situation when you have, as an international company, for example, to comply with both Russian laws and GDPR, for example, or GDPR and the local laws of the country where your headquarters is located. So Russian law does not specifically regulate this situation, and they only allow you to process personal data without individuals' consent if you need to comply with the Russian federal laws. And there is also another tricky thing about this provision. We will talk about it a little bit later. Another ground that is already in the law as well is this provision, item 7 of part 1 of Article 6 in the law, which allows processing not only for the purposes of meeting the interests of the data operator, but also as under GDPR to serve the third parties' interests. So it's very important to remember that there is already this provision in the law, although there is no court practice that would somehow support what is this third party interest that could be used as a ground for data processing. But it is, it is our in our powers to change the absence of this court practice. We can discuss these things in Russian courts. We can argue with the Russian authority in case we think that we do have the valid legal ground for processing of personal data for the purposes of, serving this third party's interests. So I really encourage all of you to think about the potential examples of those situations when the legitimate interest exists in your everyday practice, because the advisory board of the Russian authority of Roskomnadzor, Russian DPA, there is a special working group that right now works on the recommendations for the market on the legitimate interest application. There are certain tensions even within the working group, so there are different interests to comply with, and different views on what legitimate interest really means in practice, and to what extent it can be allowed for the data operator to decide at its own discretion, practically, what is the legitimate interest. So if you have any examples, anything that you think is important to mention in these recommendations, feel free to send your thoughts directly to the advisory board. There is information about it on the Roskomnadzor's website, or I'm a member of the advisory board, so if you have any specific thoughts on that matter, feel free to send an email to me. And we are really trying to keep this discussion with the Russian authority going, so that at the end of this year, regardless COVID pandemic and all these delays in all the processes, we still hope that we will be issuing these recommendations for the market in order to start this discussion, in order to discuss the practical solutions for the companies that work on the Russian market. So having said this, when we talk about particular issues that have already been confirmed by Roskomnadzor, and you will see that I use there the legitimate interest as one of the grounds, you know, because Roskomnadzor is not, the practice of Roskomnadzor is uneven in this case. We see that there are certain clients who not only once have the discussion with the authority, but are frequently checked and audited, and they confirm to the authority that they have this legitimate interest in processing personal data, and they have no complaints from the authority. So by that, we see that the authority generally agrees with their assessment and think that there are certain grounds to confirm this legitimate processing of personal data. We see also other examples. Of course, you all know probably, if you have ever dealt with Russian authority, most likely you saw that there could be different views even within one department, let alone situation when you deal with, for example, the central department and the department in some other regions. So there are different views. Of course, this is a living and breathing mechanism as to how all these concepts will work, and specifically given the fact that Russian Data Protection Authority is trying to interpret the developments of the European legislation and the practice of the European data protection authorities in a way that it could be useful for the Russian market as well. We see that there is a great potential for the data operators to specifically focus right now on the legitimate interest concept and on its application for the Russian market, so that it could make the life of all data operators in Russia a little bit easier, because you will not have to go each time to the individual to get his or her consent, or deal with the situation when your data subject has withdrawn consent and you're left with no specific ground to continue data processing. So it's really a very practical and very needed, probably the most needed development of the law right now. So really, really needed in my view. So just a couple of possible scenarios that I already discussed with the authority, and that the authority sometimes directly, sometimes indirectly, I would say, confirmed that these scenarios could really work for the purposes of, in order to confirm that there is a sort of mixture of lawful processing and legitimate interest processing. So one of the examples would be this implied consent. So obviously, as Pulina mentioned earlier, there are so many cases when individuals have a certain expectation of their data being processed for certain purposes. The most common example that is always mentioned by the authorities is the situation when you share your business cards. You do that in the having this idea that your data will be processed for these certain purposes related to your business. So there are many other situations, of course, in the commercial activity, in the business activity, when you send emails, when you have all these correspondence containing lots of data, when you have the data of the signatories in the documents that you sign and share with your counterparty. So there are many many dozens of different examples that can be mentioned in this regard, where the consent is really implied and where the parties have no objection and they do not need really to reconfirm their intent or somehow to give their consent on processing of their data, because it is already there. It is by willful sharing this data, they confirm that they're ready for you, that they're ready for their data to be processed in a certain way and for the certain purposes. Another thing that is always mentioned as well is all types of KYC procedures, and that includes not only UBO's check, but also, you know, many companies right now have this independent board members and many other people who are involved in the management of the organization, but they are not probably employees of the company. So you receive all this different personal data about these people and you need to process it. And there is no ground for you if this person is not an employee. There is no specific ground right now in the law that would allow you, unless you have to rely on this legitimate interest concept. Also, all types of regulatory claims. If you're in B2C business, that definitely goes to the all types of claims from the customers and the Russian customers customers' rights protection law in particular. There are many different situations when you receive these claims. If you are in B2B business, there are still different types of court proceedings when you can receive information about people who are not happy with how you deal with the business in Russia, and they file claims against you. You receive all this information as well as a part of the proceedings, and there are this situations as well. So that there are different types of this law enforcement and somehow related to law situations when you need to process personal data. You cannot delete it immediately when you received it, and you need to somehow, you know, assess it, and you simply cannot each time rely on the consent from the individual. It's just unlikely that you ever receive such consent. As I said, there are two things in the law that I wanted to specifically mention to you, just for you to consider it when you will think about the strategy and probably of applying these concepts to your everyday activity and to your privacy assessment from the Russian law perspective. First of all, it is the concept of necessary data processing that is required in order to rely on the rights and on the authorities that are provided to use a data operator under Russian federal laws. So there is no reliable guidance as to what necessary really means. There were different rumors, and the authority have changed their position dramatically during these last 2 years. Right now, it seems that it's not only something that is specifically provided by law, and not only that is considered to be necessary to process personal data to comply with the law. So the law, in other words, the law does not need to specifically mention that you need to do this and that, process this type of data for that type of purposes in order to rely on this exception. But you can think of other scenarios. One of the possible scenarios is this combating corruption law. This has been confirmed several times by the authorities that compliance with Article 13.3 of this law allows the data operator, any legal entity under Russian law to that matter, to decide what measures need to be taken in order to prevent corruption, in order to prevent conflict of interest. Very often in international organizations and in big Russian organizations, we see that these measures start with the registries of different interactions of the companies' employees with third parties, including with state officials. So these registries and maintenance of these registries, and even in limited cases, transfers of information from these registries to third parties are confirmed, and we have seen it several times. So this type of activity has been confirmed by the authorities compliant with the legitimate interest concept. And there are several other situations, but the second thing, except for necessary processing, that I just wanted to mention you very, very briefly. I see Sergey already, staring at me. I will be, I will end in time. So another thing that I just wanted to mention to you is this really lack of dual purpose processing under Russian law. The Russian authorities think that you need to choose only one purpose in order to comply with the Russian law. In practice, as we heard Pulina and many other speakers during today, there are sometimes different purposes. We use the very same data for different purposes, and it's important to explain this to the Russian authorities. It's important to, to develop this concept so that it could be confirmed by the Russian courts as well. The Russian law has been drafted a very long time ago, 2006. There are many, it's far from being perfect, but there are already certain provisions that we can use. We just now need to explain this to the Russian authorities and to the Russian courts so that it could be used to its fullest extent. So that would be it probably on the Russian law matters as well. I hope that I'm in time, right? Yes.
You're a little bit in time, even, I would say. So thank you for this great comparison and kind of overview of legitimate interest as a legal basis for processing. You even touched upon the topic of using legitimate interest as a derogation for international data transfers. It's awesome. And I thought you might also maybe you have given a thought to the idea that this kind of difference that we have in Russian legislation comes from incorrect translation of legitimate interest into what is in Russian called законный интерес, which is legal interest, not legitimate. Because legitimate is the one that is kind of justified. And legal it's based on the law. It's kind of required by law, which it's quite obvious that when you look into these reasons that the Russian law allows you to process the data, it actually refers to this kind of necessitated by the legal procedures, by the law itself.
Yeah, it's you are totally correct, and I think that there are many things in the Russian law that have been probably not correctly translated, and they end up in the law in a way that they are right now, and this causes lots of difficulties. Article 6 probably is the most hurting for that matter. But yeah, indeed, I hope that with the ratification of convention, we will be having this amendments to the law that could probably fix at least a little bit of all these difficulties.
Okay, thank you.